topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning. Good morning. I'm still in morning. This is crazy when you've got 10 shows that you're doing. Good, let's say late afternoon. Welcome to the Ask the Expert show, where our show today is sponsored by board certified Tina Lewert. She handles family law. Her phone number is 561-544-6861. She is an incredible family attorney. Hey, this is the last Thursday of the month. That means K. Bender Rimbaum, our community association law, our most popular show. And we have an attorney who's coming back with us today. Let me welcome Alan Swartseed. Hey, Alan.
Hi, Steve. How you doing?
Great. Glad to have you back. We got a lot of great questions. You know, if the folks would like to call in, our phone number here is 561-623-9429. Or if you're watching us right now on www.w4cy.com, you can put your chats on the right-hand side, and we will try to get to your questions. So, Alan, tell everybody, because we've got a new, huge audience. Tell everybody about K. Bender Rimbaum.
Well, first of all, Steve, thanks for having me back for round two. I'm glad you beat me up enough that you were willing to have me back this time. K. Bender Rimbaum is a fantastic firm that I started with in 2010. In 2014, I kind of moved on a little bit and then rejoined the firm a couple months ago. I now run the Orlando office, but we're headquartered in Pompano Beach. We've got offices in Palm Beach Gardens, as well as Tampa. And again, I run the Orlando office. So we really handle community association issues and mediations statewide. And we really, you know, even my mediation practice, I know we've got 3 other mediators in the firm, and we all focus on community association law. This is what we do. And, you know, it's what some of the attorneys in the firm have done for multiple decades. I've been in the industry, like I said, since I joined the firm in 2010. And, you know, we've got 21 attorneys, 9 of whom are board certified in this area of law. And before you say anything, Steve, no, I am not yet one of those. I'm taking the exam next year. This year, I just rejoined the firm. The exams come up in March, and I wanted to make sure to give myself the best opportunity to just get up and running before I decided to focus on something like that. But we've got 9 board certified in community association law, 1 also board certified in construction. So really anything that comes up related to a community association, it's something that one of us has seen at least once, twice, or 100 times.
Well, I got to tell you, when it comes to association law, unless you've been on a board or you're with a management team, you have to wear many hats. You're running a big corporation, actually.
Right. And a lot of people don't understand that. You know, when I see people making an emotional decision on the board, you actually have a legal fiduciary responsibility, which is actually the highest duty that's imposed by Florida law, to do what you reasonably think is in the best interest of the community. I mean, I literally just spent 2 hours talking about that earlier today. When I say earlier today, I mean an hour ago. I was teaching an HOA board certification class on a webinar through the firm. And that's one of the biggest things that I harp on is you got to understand when emotions get in the way, you're going to make bad decisions, and you got to treat this like a big business that you are part of the people, you know, the group that is running if you are a director. It's very important. I agree, Steve.
Yeah, and most board members do not get paid.
Correct.
It's a non-paid position, and
And
I
it's
got
a
to
thankless
say,
one as well.
yes, exactly. A friend of mine in Dallas is the president of the board in a high rise, and he can't go anywhere on an elevator without being stopped.
I believe it. It's one of those, you almost wish that there were certain conflicts of interest allowed so that people like that could have like a private elevator directly to their unit.
But God, there's so many things when it comes to running, an association. And what we do here is we take your questions. You can either call us by phone, or what a lot of people do is they just text their questions in. It's kind of like your Ask the Lawyer that you do, because I've been there, and people will come and they might have a question, they might not, but by the end of the night, they've got 3 or 4 questions.
Oh, yeah.
And that's how our show is. So, and if you're watching now on TV, we will be rolling all the classes that are coming up in February. We're not going to make Alan know all those. It's going to
thank goodness.
We're going to roll them right across the bottom of the screen. So much easier that way. And again, if you have a comment right to the right of the screen, you can write our show. We'll probably make sure we get to your questions. We're going to start with Kirk today. Kirk is from Boca Raton. Can you give me some clarification on whether our condo docs always come first or the statutes trump the documents?
Okay, well, I can give you some clarification. The answer to the actual question you asked is no. And the deeper answer is it depends. If certain language is in your declaration, we call it Kaufman language in the industry, and it basically depends whether your governing documents say that they are incorporating the statutes as amended from time to time, or that they're just incorporating Chapter 718, which is the Condominium Act. If it's just that it says it incorporates it, then really what you're looking at is, generally speaking, and again, we could spend an hour talking about this alone, but generally speaking, what you're going to be looking at is the date of your declaration when it was initially recorded. Those are the statutes that are going to apply to a lot of situations, even over your declaration. And then, your declaration basically incorporates the entire chapter of the Condo Act. So unless your declaration or the statute says, unless stated otherwise in the statutes or unless stated otherwise in the declaration, one or the other is going to control. So, a lot of people also see conflicts, I hate to be blunt, but where they don't exist. Where, it's really the statute is talking about something other than what the declaration is talking about. So be aware of that too, and contact your attorney anytime you're debating, does the statute control or does the declaration? You shouldn't be the one, unless you are an attorney well-versed in this area of law. Frankly, you shouldn't be the one making that decision. And I'll go so far as to say, even your manager shouldn't be making that decision for you.
Right.
You should really be contacting your attorney if you have that question as to any particular issue that you're dealing with.
Alan, when I was coming over to the office to do the show, I got 2 phone calls because people have access to my phone, my text, and 2 unusual questions. One was, it was from a board member, and he wanted to know if it's true that he is liable for knowing all these new statutes that are being put in front of us.
Well, so the answer is, if you're in an HOA, there is less potential liability, but the answer is, for an HOA or a condo, technically you are required to either certify that you've reviewed and will uphold the statutes and the governing documents. And the statute includes amendments to the statutes. So to some extent, you're obligated to know, and to a more limited extent, you're obligated to know that you need to contact your lawyer and say, has anything changed since the last time you gave us guidance on this issue? If it's something where you should be you should be using a law firm like ours that basically gives you that information via updates on a regular basis. I mean, Robert's got his newsletter that outlines those issues. Jeff Rembaum's got his Rembaum's Roundup, and all of those are things that I strongly recommend that everyone subscribe to that has any interest in community associations whatsoever, because they're going to be where you can find a lot of that information, even if you're not following along with the crazy things that the legislature might be doing, or frankly, sometimes the good things they may be doing. The short answer, since I've talked for a couple minutes about this, is yes, you're obligated to know, but only to the extent that you're obligated under that fiduciary duty to do what you reasonably think to be in the board's in the association's best interest. And if you have no idea what the statutes say, then you can't really be expecting to know what's in the association's best interest, because you will have no idea whether you're violating the law or not. Now, there are laws in condo land where it's not that you have to know about them, but you have to comply with them or you can be held personally liable. So the context of the question was in an HOA. So the brief answer is generally no, you don't have an obligation to know. But as a director, I would think you would want to.
Yeah, really.
And then in a condo, yeah, you can be held personally liable for not complying with certain statutes, specifically the ones that came out over the last year in July regarding all of the new condo requirements, et cetera, where, you know, the board has to go through, and I'm sure that it's been discussed ad nauseum on your show, but the new SIRS and MER requirement where you're basically studying the integrity of your building.
You know, the other question that was asked, I really probably know the answer to this, but I'm going to let you answer it.
Thanks.
Why are the laws different from condos and HOAs? Why don't they get together? Seem like that would make it easier if the laws were basically the same.
My answer is that would be way too logical. But the real answer, frankly, is that the condo statute was created to create condominiums. The HOA statute was created to basically give a statutory scheme to address what was already in place. All these covenants already existed. All these HOAs already existed. Condos didn't exist until the statute said, yeah, you know what? You can subdivide up that building. That's okay. And it'll be a separate piece of real property. And so the Condo Act generally is more restrictive because, and it goes back to what we discussed with this Kaufman language and whether it incorporates. The reason that is necessary and important is because everyone has a constitutional right, both under the U.S. and Florida constitutions, to have their contractual rights remain what they were before. And when you start changing those rights by enacting statutes that say, I don't care what's in your governing documents, now you got to do it this way, even though you've been doing it a different way for 40, 50 years, you start infringing on those rights. And you start saying, well, you no longer have the right to do X. So the legislature with respect to HOAs has been a little bit more controlled, I guess would be the appropriate word, because there are substantive rights that are being changed, and those changes could potentially be a constitutional violation. So the legislature is basically saying, we don't want to be overturned by the Supreme Court of Florida. We're going to go ahead and leave some of this stuff different. Now, from my purposes, yeah, it'd be a lot easier if I got one set of documents that governed everything. And other than this, the few issues where, by the way, one of the other reasons is the ownership of the common areas and common elements, and the maintenance of the common areas and common elements is also very different. So you'd still need to account for that, even if you conjoined most of the statutes. But I'd love to have one set that just encompasses everything. It would make it a lot easier for me to give my clients guidance if I didn't have to say, well, before we start, let me check and see, are you an HOA? Are you a condo? Are you a co-op? Are you a mobile home park? Now we can move forward with the answer to the question.
It's kind of like our show. We have to find out, well, were they HOA? Are they condo?
And that's okay.
And we had a caller. I hope Liz give us a call back. We're going to go to our next question. And it was amazing how many questions that we got. It just broke all records. We're going to go to Jen and Davey. Jen wants to know if one person holds two seats, for example, president and treasurer, do they get two votes?
Well, keep in mind, and we talked, I believe, very briefly about the distinction between officers and directors. So your officers are whatever the bylaws say they are. They're the people that do certain things within the community. Your directors are the people that vote. So you're not going to hold two director positions as one person, unless somehow you figured out a way to own multiple corporations, both of whom have designated you as the director on behalf of multiple units, which is rare, but I guess possible and definitely not recommended. So the short answer is no, you're not going to get two votes because you're not going to be two directors at one time. You might have two positions as officer, but not as director. Steve, you mentioned the different hats people wear. You know, an officer and a director are usually the same people, but they're not always. And then there's also the members who are not voting at these meetings, but get to attend them when it's a board meeting. So again, bottom line, no, the short answer to the question is no, because the directors are the ones that get to vote, and you're not going to be two directors at one time, even if you're two officers at one time.
Okay, let's go on the phone lines to Claude and Tamarack. Hello, Claude. Claude, are you there? Do we have Claude one more time? Claude, are you there? Okay, let's put him back on hold and see if we can get him to come to the phone. We're going to go back to our text, our questions.
Oh. Did we just hear Claude?
I think I hear him.
All right.
Okay. Do you have a question for Alan?
Yes, I do.
Go right ahead.
Okay. My question is, we had an annual board meeting where the proxies were 22. We needed 50 altogether, and it didn't make it, but the elections took place, and the situation ends up being that there were 5 vacancies to fit on the board of directors of 9. But since the proxies did not did not make the amount that they needed for a real election, and with 5 vacancies, there was only 2 other homeowner members that wanted to be in it. Can the old board, because there were vacancies, can the old board during election season, not in the interim of the year, can they allow those who want to be part of the board with the vacancies for them to say yes or no, because they might not be in full agreement with the old board members or not?
So if I'm understanding correctly, you had an election meeting scheduled, but you didn't have a quorum, which means technically you didn't have an election, correct?
Correct.
Okay. So
Correct.
technically the old board carries over, and they get to decide whether the other 2 people that wanted to be on the board can sit, or if they're just going to remain. Generally speaking, when you can't get a quorum, the old board just carries over, and you don't need to go further than that. If one of them or more of them were willing to resign, or there were vacancies after that carryover, in other words, one or more of the directors who were on last year just said, you know what, forget this, I'm not interested anymore, this was too much of a hassle for me, then the remaining directors would appoint whoever else among the members is willing to sit that they want on the board. It doesn't go the other way around, the way that I think you were describing it, which was that the people that wanted to be on are automatically on, that were not previously on the board, and they get to decide who among the former directors gets to continue. The former directors continue, and they get to decide which of the new members that might have sat if the election had taken place are going to be on the board this year.
Okay, so just to be clear, because then I have a part 2 of this question. My circumstance is that, let's say, during election period, there were about 40 people there. And like I said, 2 people wanted to be part of the board, where because there would be, for the following year, there would be about 5 vacancies instead of the complete 9. Couldn't the 2 of the members that live in the community say, I want to be part of the board? Whether the board will continue, the old board will continue, but those 2, wouldn't they not have the right to be on the board, being that there were vacancies, without an election, obviously? Because if it would exceed 9 people, then obviously, yes, the proxies would carry on for the following time that there would be continued election. Does that make any sense, what I just said to you?
To some extent. I mean, if what you're saying is there are 9 open director positions overall and 5 of them are vacant, 4 of the directors from last year are carrying over, those 4 directors get to decide which 5 other people to appoint. The people that were interested should be the first person, the first people that those carryover directors contact, because you already know they're interested. But it really is up to the existing directors to make a decision as to how they want to run everything. What they should be doing, if they were close to having a quorum, is, as you implied, and I think you were starting to say, they should have adjourned the meeting to another date to see if they could get a quorum. But when I say should, I don't mean they were legally obligated to. It just means that that's the way that they could have gone if their interest and their intent was to try and fully comprise, at least to the greatest extent possible, that board. Now, they should put those 2 people on, because those were 2 of the people that wanted to be on the board. But if there was no election meeting, there's technically no obligation to add them to the board. I think that it's questionable, but because there was no election meeting, there was nothing that occurred. Unless you're in a condo and they declared not that they wanted to be members, I don't really see a legal basis to obligate the existing directors to put them on the board. Does that make sense?
Does that answer your question, Claude? Does that answer your question? Okay.
The answer is Claude's not sure, and he's not really happy with it. but that's my analysis. Without looking at the statutes directly, that's the way that I would evaluate it.
Okay. So if you have a question, we're going to go to break right now. When we come back, we will have more with Attorney Alan Swartseed. Do you have the phone number, the toll-free number for K. Bender Rimbaum?
I don't have the toll-free number offhand, but if you contact our Pompano office, that'll get you through to whoever you need. It's 954-928-0680.
Very good. K. Bender Rimbaum, they're with us the first and last Thursdays of the month. We're going to go to break. When we come back, we'll have more. We'll be right back. Okay, we are back. This is the Ask the Expert show. We're with you every Thursday from 5 to 5:50. And if you want to watch us on TV, you can go to www.4cy.com. You can also listen to the podcast by going to the same site. We're answering your questions tonight on on HOA Condo Association law. And what we do is you can either call in You can call us at our number here at 561-623-9429, or you can write us like you've been doing for the last month, or you can actually write on the side of the screen. We'll take your questions that way. So we're going to go to our next question now, and this is William in Palm Beach. It says, our management company instructed me I should not CC the board members when I email the management company staff at our condo association because of problems with our roof, water, sprinklers. Can they actually do that?
I don't know that they can necessarily say you're not allowed to CC the board directly, but they're probably trying to direct all communication through the manager for the purpose of not having the directors bombarded with emails from every member of the community. The property manager is there literally to serve the association. And yes, to some extent, so is the board. But if a manager's been hired, you as a member of the community are paying their salary. You might as well just go ahead and let them do their job and make sure that, that those items that you want passed along to the board get to the board. If that instruction has been given, I'll just be blunt. Chances are the board is ignoring every email you send. And that is, again, for the purpose of ensuring that the board is able to live their lives as volunteer officers and directors of a corporation, not for profit. And that even if they are using that email address only for association purposes, which, by the way, is always my suggestion, if you're a director, have a separate email address just for association business. But even if they only check that, once every other day, there may be multiple emails from the manager that they can't see because they have 50 emails from members that the manager should be dealing with. So can they tell you you are directed and legally obligated to ignore the directors in your emails? Probably not, but they could send a cease and desist letter directing you to do it. They could, basically treat you as a nuisance if you're not willing to follow the association's procedures. And if there is a policy in place that the board has adopted, or a rule, regulation, whatever you want to call it, that basically says, we're going to hold the members accountable for only communicating with the manager, that might be enforceable. But without that kind of rule in place, I would do it just as a courtesy. But, if you really want to push the board, if you want to bombard them and expect that they won't really maintain and operate the community the way that they're supposed to, I suppose that's your prerogative.
Okay. Hey, let's go to Monica in Boca Raton. She's got a question about disqualification. She said, my question is in regards to our annual elections.
Okay.
What disqualifies a candidate, and when is disqualification determined?
Well, it's different in a condo and HOA, but in both, if you have a felony or something that is a crime that would be a felony if it was committed in Florida that you were convicted of, and that your civil rights have not been restored for at least 5 years, meaning you're still in prison, less than 5 years ago or whatever, that's one basis to reject a possible nominee, candidate, whatever you want to call it. That 5-year period for an HOA is it needs to be 5 years as of the last date that someone could be nominated. Same with, I believe, and I'd have to review the statute again, but I believe it's the same in a condo for that one. And then another one is if you're delinquent in payment of an assessment or other monetary obligation to the association, that's also going to be potentially, or it will be, grounds for you not to serve on the board. In a condo, if you're 90 days past due, you're technically automatically off the board. I believe the same applies in an HOA. And I believe in an HOA also, if you are delinquent at all as of the date that you would be last allowed to serve on the board, that might be the 90 days. I might be mixing these up again. I would need to look at the statute to verify the specific dates. But it's basically if you owe money to the association, or you've been convicted of a felony and haven't had your civil rights restored for at least 5 years, or you've been accused of theft of association funds, and you haven't had, and there's an actual police activity and I can't think of the word, an indictment that's been brought down. In other words, the state's attorney is actually pursuing it. Those are some of the reasons. And obviously, if you've been convicted of that in recent history, you can't serve on the board either.
Here's an interesting question from Jack in Boca Raton. He says, our condo exterior is being done where they are changing the color. So it's a common element, but a vote was never taken. What can we do about this?
Well, presuming that a vote was needed, which most likely it was of the members, because that is generally called a material alteration if you're changing the color. If it's something that you're doing for the purpose of protecting, even though you're changing the appearance, that's okay. But if you're changing the color, I don't know that would protect the association. You're just changing the color. What could be done? Well, you could try and get a temporary restraining order, basically an injunction that a judge would tell the association, you need to stop doing what you're doing. Now, for practical purposes, chances are that judge is going to tell the association, go get the vote. And the association will try and get it. And then what happens when they can't get the vote is, well, you've just spent association money both during the litigation and on the initial painting project. Now you have to spend more money painting it back to the original color. So for all intents and purposes, what you're doing is, unfortunately, as much as this is not what you want to hear, you're basically costing yourself more money by way of assessments.
Alan, if you are going through a divorce, you go to family court. If you've committed a crime, you go to the criminal court. What court do you go to if it has to do with the association?
Well, you're going to go to civil court, but it depends because there are certain things you need to do before you can file certain lawsuits regarding a condo or an HOA. In condo world, which is a different world from what I call it, you're basically looking at potentially arbitration. My preference, as I mentioned, I'm a certified mediator. I would much rather go to mediation, which is the alternative that was put in place about a year ago. Arbitration is with the DBPR, and that's going to be basically where someone makes a decision that is, unless the parties agree otherwise, non-binding. In other words, you're going to take the time to basically go through a mini lawsuit. And at the end of that, you've got a piece of paper that says, if you want to enforce this, go file a lawsuit. Whereas in mediation, you get the parties in a room, you make a determination of, okay, well, can we settle this with someone that's impartial, trying to push the parties toward that settlement? And if you're not able to settle it, or if you offer mediation and the other party ignores it or doesn't agree to mediate, then you file your lawsuit and the judge will make a decision. But I find mediation overall less costly, more effective and efficient because arbitrators are allowed to be just that, arbitrary. And, not to knock the DBPR, they do good work. But the reality is that because of that case law that says that an arbitrator in this capacity can be arbitrary, you never know what you're going to get. There are new arbitrators that come in all the time that don't necessarily have the background in community association law. You've also got a lot of decisions that are made even by the same arbitrator on the same community, on almost the same facts, that it comes down completely different for whatever reason. So bottom line, the answer to your question is we end up in civil court, whether that's circuit or county, depends on what the lawsuit is about, because it could be a covenant enforcement, or it could be a foreclosure, or it could be where someone was injured on the property. That's all going to be civil by the time you make it to court.
Okay, let's go to our screen. Linda, she wants to know, can 3 members of a 7-member board appoint themselves as the only board members who can interview insurance agents and exclude all the other board members and interested owners?
Okay, because of the way that the question is phrased, my answer is no. Okay, and the reason for that is, can 3 of 7 directors appoint themselves? You need 4. You need a majority. So a minority of the board. The only way that this could work if as 3 of 7 is if you've got a quorum of 4 at a board meeting and 3 of those 4 vote in favor of delegating that authority to these 3 directors. But generally speaking, you can't unilaterally decide as 3 of 7 directors without a board meeting that you're just going to go ahead and say, you know what, we can do this now. So again, the short answer is as phrased. The answer is no. But if you do it the right way by having a board meeting, even if only 4 directors attend, 3 of them is a majority, and then you've got the proper vote. But you can't just delegate yourself the authority. 1 or 3 or even a majority of directors don't have the authority to act without having a board meeting or at least a vote by written ballot or written instrument, which is something that's allowed that a lot of attorneys don't even know about under the Nonprofit Act.
She is actually following up.
Okay.
If the bylaws state that the board and committee meetings can be, I don't know if you can see it up here,
I can,
recorded if the owner submits the intent to record in advance, can an owner be denied the opportunity to record at the beginning of the meeting?
No, Florida law is clear. You got to allow that recording. All open board meetings. The only way you'd be able to avoid that is if it's a closed meeting. In other words, it's with counsel for the purpose of discussing ongoing or potential litigation, or it's with one of your you're discussing employment matters, of the association. So generally speaking, any meeting that needs to be open in general is also subject to being recorded.
Okay, and with a follow-up question, are there any special sorts of board meetings or committee meetings that cannot be recorded if the owner complied with all the requirements of the bylaws regarding recording?
Well, I think my answer to the last question is pretty much the same as the answer to this one. Unless it is a closed meeting of the board or committee, you got to allow the recording.
So then, can a board member discuss condo business on email? How does that differ from holding a board meeting and not allowing owners to attend, since owners are not privy to the board discussion?
So the Florida statutes are also clear that the board can communicate via email. You just can't vote via email. Okay, so the difference between a board meeting, which is conducting association business, versus emailing to discuss, usually my recommendation is you use the email to figure out what are we even going to consider during the board meeting. Is there something that we're just completely ruling out? And if the answer is, well, we've ruled this out, then you don't need to discuss it at the board meeting unless someone specifically asks about it during the board meeting. So that's the short answer is you're allowed to communicate via email by statute. You just can't vote via email.
Okay, we're going to go and take our last commercial. Let's give everybody the phone number again, the Pompano number.
Sure, and Jeff was kind enough to text me the.
He's good at that.
Number. Not that you're surprised, Steve, but
yes,
that is 1-800-974-0680, and again, Pompano, which will get you to anyone not toll free, is 954-928-0680. And I saw a bunch of the things that are scrolling across the screen. Just to let everyone know, that's a few of the things we've got coming up in February. We just added an assessment class that I'll be teaching in late February. We've got a couple others. So I would just invite everyone to take a look at our website and in the calendar section, rather than wasting everyone's time going through everything that's going on, since you so kindly posted everything at the bottom of the screen.
KBRlegal.com.
Yes, sir.
Great website. There's so much educational information on there. We're going to go to break, and we'll be right back.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Wow, that was a short break.
That was the shortest break I've had all week.
Yeah, that was a short break. Anyway, we're here with Alan. He's an attorney with K. Bender Rimbaum. K. Bender Rimbaum is, gosh, they've been with us almost 6 years now. We do a show the first and last Thursday of the month. We welcome your questions. This is association law questions. Alan, did you know you were going to go into association law?
No, matter of fact, I started out, I started practicing law in 2008 with the full expectation that I was going to be a transactional real estate lawyer. I was going to do real estate closings and commercial buildings, things of that nature. And in case anyone can think as far back as 2008, that was not a great time for commercial or residential real estate. So I ended up in foreclosure, in mortgage foreclosure for about 2.5 years. And then I joined K. Bender Rimbaum doing community association collection. And here we are today. But no, this was 100% not my intent and 100% something that I'm thrilled that I ended up in.
Let's go back to our questions. This is Julie in Boca Raton. Can a condominium board member be removed for not following Florida Statute 718?
It depends what portion they're not following. So the short answer is yes, there's a procedure called a recall, and you can remove a director for any reason using that procedure. But if it's specifically for wrongdoing, they need to actually have breached some fiduciary duty. In other words, it goes beyond just, well, I made a mistake. It's got to be real malfeasance. The short answer is it depends whether your governing documents, specifically your bylaws, allow the rest of the directors to just vote someone out. Chances are they don't. It's rare that type of provision is included, but you never know. I would check your bylaws to see what is required to remove a director. If there's nothing in there, then chances are it's just a matter of, well, if they did wrong and it was a unilateral act that the board didn't actually approve, you might go after them for that. If they're just voting in ways that make no sense, just outvote them during your board meeting.
You know, the hottest game right now is pickleball, and we get so many questions about pickleball court. So I chose one. Says, what if a condo is adding pickleball courts markings to our tennis courts? Is that considered a material alteration? What if we wanted it's going to serve both purposes, tennis and pickleball?
I think that one's actually more questionable than what I anticipated you were going to end with. Because I thought that it was going to be that you were changing from tennis courts to only pickleball. That, I would say, is a fairly clear material alteration.
Yes.
But if you're just taking what's already there and adding to it, and you're not taking away the tennis court markings, you're not taking away the fences that usually surround the tennis court, you're not changing the flooring material, the answer is it's going to be up to a judge. That's really, I would say it might qualify as a material alteration because you are changing the overall appearance, but you're not changing the function. You're not changing anything else. It's one of those things that if someone came to me back when I was representing individuals, now, our firm really only represents community associations. But, a couple of years ago, if someone came to me, I would let them know during a consultation, listen, I might be able to take this on. We could win, but it's 50-50 at best if we try and challenge it. Because I think that the association has an argument that might be valid that says we're not changing the use, we're not changing the function, we're not changing the fact that the proper markings that you would use to play tennis are still there. So I think that there's an argument to be made either way.
Okay.
That's the real lawyer answer for you for once.
Okay. Let's go to Parker in Deerfield. Did the request to inspect condo documents change from 718 to 720?
I'm not quite sure what that means. The statute is almost identical. The only thing that is different between the statutes that's materially different are the time frames of how long each type of community needs to retain those documents, what needs to be placed in them. But in reality, both of them contain what I call a catch-all. That's basically any other records associated with the association's business. So really, the answer, I guess, is no. I'm not quite sure what the exact question was, but it sounds like you're asking, are the statutes different? And the answer to that is really only in the time frames that you need to keep things.
Okay. Let's go to, we've got about 5 more minutes left in the show. We're going to go to, let's go to Brock in Hollywood. There was a special assessment approved by our board members within 14 days to pay $6,000 per unit for 16 buildings and pool house to be re-roofed. My unit is not on the list. Is this legal for me to have to pay this?
I'm not quite sure what list you're referring to. Yes, a special assessment generally is legal. As long as the association provided notice at least 14 days in advance of the meeting when they were voting on it, and that notice specified what they were going to consider, that it would be a special assessment and the amount and the nature of what they were going to do with the money. Yeah, I mean, it's super unfortunate, but from what I can hear, it's entirely feasible that this may be an emergency situation where the roof is caving in and they got to replace it right away.
Right.
And they can't take the time to go out and try and get a loan. So they have to charge the members and try and get this money as soon as possible. I'm not saying that's what happened here, but that's what it sounds like to me. Again, with respect to the list, being on the list or not, I'm not quite sure what that means. If you're saying you're not included in the number of buildings that need those repairs, depends whether you've got a separate declaration and a separate set of covenants and a separate community association. If not, then the only way you would get out of that special assessment is if your governing documents actually say that there's some kind of separate budgeting process or separate assessment process or something for each building of the community, which I have seen in the past.
Okay. Let me see if I can get a short question here.
Sure.
And we understand that Comcast is having some kind of outage tonight, so I hope it's not affecting our listeners. Is painting the residential buildings in a condo considered material alteration requiring members to vote?
So I think we kind of touched on this earlier in the show. It really comes down to, are they changing the appearance of the building? If you're using a different shade of the same color, I don't know. If you went from, light beige to bright pink, then yeah, chances are that's a material alteration that's going to require a member vote. But also look at your governing documents. If you're in a condo, if your declaration says that the board is allowed to make material alterations, that's the answer. Or if your bylaws say it. So you probably need to look at your governing documents. Generally speaking, that's something that will probably require a member vote. But I just can't give a straight answer because it depends on your documents.
Well, we've come to the end of the show. We've got several people who wrote in. We will take their questions and add it to next month. Alan, you're a wonderful guest.
I appreciate that.
I love the way you explain everything, and you put it into layman's terms that we can all understand.
I certainly try to, Steve. Thank you so much.
And let's hit that toll-free number.
Sure. 800-974-0680.
And the name of the firm is K. Bender Rimbaum. They handle association law. And I am telling you, we've been associated with them for the last 6 years and get nothing but rave reviews from their clients. Alan, thank you so much. And we will see you all next Thursday at 5:00. Have a good weekend. See you then. Thanks, Alan.
Thank you. And thank you, everyone, for listening.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.